evening, ladies and gentlemen. Karan, you can unmute yourself. Good evening, ladies and gentlemen. Welcome to the second episode of the IP webinar series. And the series is about the best practices or for IP protection and enforcement, hosted by Vakilsearch. And the speaker for this evening is Mr. Karan Agarwal, who is our senior IP lawyer at Vakilsearch. I'm Charles, host for this evening. I'm thrilled to have Mr. Karan and also the attendees as well. And just at the outset, I just wanted to tell all the attendees who are just viewing us from various social media platform or joined us live through our channel that there is some exciting giveaways and surprises that is lined up for everyone, which we will be revealing it at the end of this webinar. Before we jump into today's meeting or the webinar, I just want to give a quick glimpse of what the last webinar on how we identify company trademark, patent, design, and copyright, and we specifically delved deeper in the area of pharma, IT and software, dairy and luxury products, and daily products, and the different classes that were involved in this particular trademark and registration. So, Karan, most of the attendees know you, but for the benefit of people, those who are here for the very first time and joined us for this meeting, may I request you to introduce yourself and also give me a quick glimpse of what we can expect this evening and the agenda.
Thank you, Charles. Hello, everyone. It's a pleasure to be here. As Charles has already given a brief intro about me, I'm an IP attorney and I've been practicing in intellectual property rights for around 8 years. And I have been handling both prosecution and litigation matters with respect to trademark, copyright, patent, and design. So again, this major session is about actually understanding how do you apply the trade, how do you apply different kind of IPs. Whenever you're starting the business, the first step is you need to apply. So in this session, we're going to discuss about that. See what are the ways, what are the processes, what are the different kind of disputes that you might face when you apply. So that is the major agenda of the discussion.
Thanks, Karan. So let me quickly jump into the discussion by asking the first question. In the last episode, we discussed on how do we identify a company's intellectual property. In this webinar, start or help us understand what is the process and how to protect or apply for a trademark.
Okay. So again, trademark is one of the most common, one of the most used IP by any and all businesses. If before starting, I will bifurcate to reiterate for everyone's knowledge. When we talk about IP, there are four different kind of IPs: trademark, copyright, patent, and design. These are the four most common ones. There are three other kind of IPs also. But again, when we talk about anybody is planning to start or launch their business, you need to apply for a trademark as the first step. So when you apply for the trademark, the few basic information such as the details of the applicant, address, you should have these in handy. You should have a very nicely curated logo or a brand name ready. So one of the most important thing is whenever you apply for a trademark, you need to create a very unique brand name, very catchy brand name, or something a non-dictionary word. You find a unique brand name. Once, yeah, then you can reach out to your IP attorney. He will help you with it. He will help you in checking if there is a similar trademark in existence or not. He will do a brief search for you. On after that, you will proceed with filing of the application. You will file an application with with the trademark registry in India. Once you file the application, it goes through a few steps, such as it goes through a formality check, fail or pass. So if there is any kind of technical issues that the trademark registry has, after that they will issue an examination report mentioning any kind of objections or any kind of issues that they have with your trademark. So they mentioned their pointers. So we have to file a detailed response to the same within the deadline. Once we file the response to the same, either the mark gets accepted by the trademark registry and they publish it in the trademark journal. If in case they still feel that the response after the response that we have filed, they still have any specific objections, what they will do is they will allot hearings. So in trademark matters, they might allot hearings wherein they will hear the arguments through a video conferencing or through in person. So once you are able to clear out the arguments, once you are able to overcome the objections during hearings, the mark will again get published. It is published for a period of around 4 months, which is a period for any third party or any entity to oppose your trademark if they have any issues. So objection is wherein the trademark registry raises any kind of objections. Opposition is a stage where a third party can file any kind of opposition against you. Once that period of 4 months is gone, then the trademark will directly automatically move to the next stage of registration certificate issuance. That is how the basic
Okay.
process timeline of trademark goes. And yes, after you have got the registration certificate, every 10 years you have to renew it.
Okay. Karan, I heard you say in the discussion that people do tend to get a lot of objections. That's what I heard. So, since you mentioned that part of objection, why don't you tell us that what kind of issues do people commonly face when they apply for a trademark, and what kind of objections will be raised by the department?
Okay. So again, whenever you file a trademark, there is most averagely around three different kind of trademark objections that you will see. Firstly, the objection will be as to the distinctiveness or the uniqueness of the mark. So the mark has to be very unique. You cannot apply for the word bottle as a trademark, but it's a very generic term. Next is the mark should not be descriptive. So you cannot apply for the trademark apple for selling apple fruit. So it's generic, it's descriptive. It's descriptive of the exact business. You cannot apply for that. So third aspect is if the trademark registry find that your trademark is similar to somebody else who has already applied. So these are the three different kind of objections usually trademark registry raise, wherein they will ask an explanation from our side to argue as to how our mark is unique, how our mark is not descriptive of the nature of the business, and how our mark is different from the other similar marks in existence in the records. So again, when you are having this objection, to make sure or to take some steps that you don't receive these objections. When you are applying, as I said initially, also get a non-dictionary word. So the first and
Okay.
the second objection you will automatically be able to overcome. With respect to the third objection as to any similar kind of trademarks, make sure to get a search done. Make sure to get a trademark search done so that you know your mark is unique.
Thanks, Karan. So, what you're trying to say is the first and the foremost fundamental thing that people get objected for their trademark application is it's not unique because it is something very similar to somebody else. So, uniqueness is a key, is number one aspect. And the second thing is must not be already existing in the market, in the prevalent market or something, the design or whatever it may be. It should not be available. That's what the fundamental thing that you're saying for the objection, right?
Exactly.
Yeah.
Exactly.
Yeah. So, but Karan, recently, I mean, very recently, there was, I think, there's a dispute between Oreo and Fabio biscuits. These guys are very big industry giants. So, what is the exact dispute that was happening, and what learnings that we could get from that particular dispute? Can you help us understand on that?
Okay. It was indeed a very interesting recent judgment that was passed, and it was a matter of dispute, wherein again everybody would have seen an Oreo biscuit. It has a blue wrapping with two biscuits and Oreo written on top of it. And similarly, there is another brand of biscuits for Fabio. So again, this was a dispute on two basic facts as to the overall look and feel of the product. Both the products were having the same shape of the biscuit packaging. Both had the same color combination. Both Fabio and Oreo had the ending syllables very similar. So Fabio, Oreo, EO, EO. So the syllables were coming out very similar. So because of which it was a clear case of wherein the trademark registry, wherein the court specifically held that yes, there is evident similarity. There are chances of confusion. So again, this case is still pending final judgment. But again, this was a very interesting case wherein the very two major giants have come up with something similar, and it was a matter of dispute. So one of the things that again, as I said initially, also whenever you are applying, firstly get a very different trademark. Don't try to don't try to copy something which is already hit in the market, or don't try to model a big brand, remodel a big brand. Don't try to do that. And again, make sure whatever packaging that you're doing, there should be proper research and proper research and effort and R&D done when you are finalizing it.
So every brand must be very cautious in terms of positioning their brand properly, whether be it a logo or a design or a color selection, whatever it may be. Even if it is syllable, right now what you said, Oreo and Fabio, even the syllable can get your brand trademark gets registered. I mean, rejected. That's what you're trying to say. Even if it is a small minor similarity, right? Yeah. Karan, what is the process
Yeah.
of applying for a copyright? Okay, this is a two-part question. The first part of the question is, what is the process of applying for a copyright? And the second is it different from trademarking? And what are the common issues faced by clients when applying for a copyright? For example, right now, people, those who are watching, might have the same question. The difference is, can you help us understand that? Can you shed some light over there?
Okay. Sure, sure. See, trademark is, again, as the name says, a mark which is signifying a trade. So any brand name that you have, which you put it on your on the top of the product, that is trademark. Copyright is something, any kind of unique content that you create, any unique content, be it a video, be it a poster, be it a pictures, be it animation videos that you are creating, or you're writing a new fabulous code of your website or a mobile application. Anything that you can put down on a paper, or anything that you can put down as a coding on a website, all those things can be copyrighted. The basic process of how to apply for a copyright is, again, the first and foremost thing is, again, the exact work, the exact poem, story, video, what is the exact work that you have created. You need to provide that to your IP attorney, along with the time when you first published it, the date of the same, along with all the details of the applicant. So on the basis of that, the documents will be created by your IP attorney, the POA, the different applications, and then it will be accordingly filed as per the category. So there are few categories under copyright, and as per the specific, the nature of the work, if it is a video, it will come under cinematographic work. It's a poem or something, it will come under literary work. So accordingly to the categories, an application will be filed with the Copyright Office. And once you file the same, it will go under a scrutiny by the Copyright Office, wherein they will issue a discrepancy letter. In the discrepancy letter, if they have any technical issues, or they have any objections, or there is any similar kind of work already existing in the records, they mentioned as an objection. We have to file the response to the same, and once the response is filed, accordingly it will move to the registration stage. So that's how what is the basic process.
Thanks, Karan. Karan, quick question, Karan. This is, can you share an instance of like someone copied a copyrighted work? You know, what happens when that happens? Like somebody has copyrighted a work and somebody copies that work. What happens there? Like how people can take steps, to avoid these things.
See, one of the most important aspect is to be vigilant. Whenever you are applying whenever you're applying your copyright, or whenever you're applying any IP, the most important aspect is people feel it's a very common perception that you have applied your trademark or copyright and patent and your work is done. No, the next step starts after that. You have to make sure to have a check if somebody is similarly is coming up in the market, or is copying your trademark or copyright or patent or design. And then accordingly you have to reach out to your specific IP lawyer who can advise you. In the current case, for as you said, for copyright, so like there are various instances. For example, if you have created a unique audio or a video, and you have created, and it's having hundreds and millions of views on YouTube and everywhere, it's a very
Exactly.
common scenario. Somebody will take the background of that music and start using it, and for their own video they put something else on the front. So that is a clear case of copyright infringement. So there are few instances or small cases. Like again, there was a case wherein somebody copied the music of KGF 2. Everybody would have heard of the movie KGF 2. So somebody
Okay.
copied the music of KGF 2, and put up some posts and videos on Twitters as a background. So that kind of thing. So there was a copyright dispute around that, and it went to the court, and the court ordered an injunction. Okay, you're not supposed to use that music. So that kind of things can happen. So there are various ways you can take action. You can send through a legal notice. You can go to the court, be it district court and high court, and there are ways how you can take action. So, but yes, this is how people usually end up copying your copyright.
That's interesting, Karan, because looking at what you said right now, I think that people can't just take whatever is available online and take that and use it, because it is work of somebody else, and it has to be, your work has to be unique, and you can't copy and take things up. Now, Karan, tell us, what are the process, steps involved in applying for a patent? Is it too complicated? Like, what are the things, what I should know? Like, if I'm applying today for a patent, what I should know?
Okay. See, patent, I would say, is one of the most, no, I won't say complicated aspect of all the IPs, but in which when you're drafting a patent application, a lot of effort and work has to be done. So a trademark or copyright or design, these are simple wherein you need to provide the basic pictures or the exact trademark or the exact work. In patent application, you have to specifically draft the invention. You have to specifically explain the inventive aspects about your invention in quite a detail. So whenever you are applying for a patent, so first aspect, yes, you have to do a very detailed search. So it's a very, because there's so many inventors hiding in every corners of the world, you might not know somebody would have already applied for the patent. So make sure to do a very detailed patent search done before even proceeding further. Once a patent search is done, then you apply for a patent application, and it can be applied in basically two formats: as a provisional patent application and as a complete specification patent application. Provisional patent application is when your R&D is half and half done, or like 70-80% of the R&D in your invention is done, and you're ready, and you are almost, you want to make sure that your idea is protected. You apply for the same as a provisional patent application. So the basic, what does it give you? It gives you a priority of like 12 months, so that for 12 months you have the time to complete your invention, complete the R&D, and then you apply for the complete specification patent. So that is what it gives you. It gives you the gap. When you are applying for the provision, when you are applying for, again, be it a provisional patent or a complete specification patent, make sure you are conveying the inventive aspects in quite a detail to your IP lawyers. That is one of the most important aspect for acceptance or rejecting of a patent application, is to explain the inventive aspect in details. Second important aspect is make sure the processes and the steps are very clear. So many times people they do not give a very detailed flow. See, again, right now when you're filing a patent application, it's like you are explaining your product. So you have to explain from top to bottom, from smallest of nut to the biggest of metal piece in it. So make sure whenever you are explaining how the exact product or the invention works, what are the steps involved in it, what are the temperature it is going to be, what are the grams or the milligrams of material that you're going to put. You have to explain all that in quite detail, and support it with lots of drawings as to of each part, how the each part works, how the each part is connected to each other, different parts, that you have to provide. Drawings, you can, it's not a compulsory thing to provide the drawings at a provisional patent application, but yes, if you have a unique product, you need to provide proper drawings at least at the stage of complete specification patent. Or if not, you do not have any drawing based product kind of a thing, then you at least need to provide a detailed flowchart of how your invention is working. So again, this is the basic application aspect. So once you've applied, the patent application will move on to the next stage as to it will get published automatically. You can even file a small application and get the publication expedited. Once the patent is published, then you have to file a request for examination, which is a compulsory step. Once the request is filed, after that you have to the examination report will be issued. You have to file a detailed response to the same, and once you have filed the response to the same, the patent office will issue a hearing date in which you have to argue the matter and file detailed written submissions in it. So once you have done all these 4 5 steps, finally the patent office will determine whether to accept or refuse the patent.
Thanks, Karan. That's very interesting. Now, moving forward, now 2023 people call digital era time for SaaS products, software, technology. So can they be patented in India? Since it seems there are various disputes among like rounds and right over the software. And all. Can you throw some light on that as well?
You are very right. Again, software has been always like a chink in the armor for the patents. So it's like, as per Indian laws per se, you cannot directly apply for the software per se exactly. However, you can apply for the software if combined with the hardware. So this has been a point of dispute again and again at the relevant instances. Ki what is the right hardware? In what instances, what inventive aspect should be available in the hardware also? So, like, be it Microsoft had a very recent dispute with the patent office as to one of the patents that has been. There was an objection from the patent office as to there was not a proper hardware. So again, it went into an appeal. So again, this software industry is something. Whenever if anybody who is here has a software based patent or software based product, so first thing is, make sure if you want to get a patent into it, make sure you are able to bring forth a clear cut hardware into it. You need to make sure, you need to showcase when we file an application with the patent office, we need to showcase that this software needs a very unique kind of a hardware to work along with. Once that is there, that will be accepted. However, in like foreign countries like USA, UK, EU, all these other countries, many other countries, they have a very software friendly patent laws. So again, in those countries, this is not a requirement. But yes, in India, this is as of date, it's a requirement to showcase some hardware involved in the software. As an alternative, if you feel that your product is completely software and there's no hardware at all involved, then in that case, the best way ahead is go ahead with filing the coding of the entire software as a copyright application.
Thanks, Karan. So we looked at the copyright part, we looked at the patent part. Now we're going to move to this next, the design registration. Like, how is design registration different from patent? What are the processes involved for applying for design application?
See, okay. So again, the same department, designs and patent office, handle both design and patent matters. However, there is a not very, it's a quite a difference between both aspects. So patent is specifically about the invention of a product, how the product works, what is the problem it is solving. It is solving a problem in a much better format than the earlier products. Design is simply how does the product looks from outside. Simple, as simple. How does this my specs that I'm wearing, how it looks, the shirt design or the coat design or the wristwatch design? As simple. Any design, how a product looks from outside. What is the basic creative or the unique design you fitted of your product? That you can apply it as a design registration. When you apply for a design, there are few things that you need to take care of. Firstly, your design should not be publicly available. It should be
Okay.
something new. It should be something novel altogether. If it has been made public, you cannot apply for the design registration for the same. Then, when you are applying for the design registration, ask again, the details of the applicants are required. Power of attorney is required in the favor of your lawyer. Second aspect is specifically is pictures. So a very detailed, high definition pictures of the product from all angles, like six, seven different angles that you can
Okay.
click the pictures. We require the same. Preferably, whenever you are clicking pictures, make sure to click it on a very contrasting background. So if you are creating any dark image product, just get it in a white background, or if it's a light color product, get it on a black background. So it's a very important aspect or a very common objection that the trademark that the design office have. So get a very clear pictures. We file representation sheets, the POA, and other documents. We select the right industry. Design has a
Okay.
specific kind of a classification that is called Locarno classification. Select the right industry that you want to apply the design in. Once you select all these things, apply for the design application. Once you apply, after that, the design office will examine in a few months and will issue an examination report. In the examination report, they will mention any and all kind of objections. If they have found a similar design on any other e-commerce or platform or Google or a similar design that has been already applied. So they do a very detailed kind of a public search. Once they issue the report, you have to file a response to the same. Once the response is filed, after that, again, the design will automatically either get accepted and registered or There will be a hearing allocated wherein the design office have still further objections or any issues, which they will decide after that. This is
Thanks, Karan. So I'm going to wrap up by asking the last and the most important question, Karan. What significant issues should one take care of while applying for IP protection? And I just want you to give some examples so that people could like see in real time like what exactly happened and how they have overcome it and what challenges that they will face and how they can overcome as well.
okay. See, when you are anybody starting a business and want to ensure that the IP is 101% protected. So the first and the most important step that you should take is get a IP due diligence done. Check, get a contact a lawyer, get to know what all IPs are protected. Whenever you're starting a business, most of the people are like they don't know. That was the reason we had the last webinar for how to identify IPs in your business. So if you can reach out, you can check the first episode for the same, how to identify the exact IPs that you need in your business. Once you identify that, once you have done the due diligence and got the IPs identified, then you need to apply for the same right away. So the basic another major issue people is कि we will start the business after 1 year, 2 years, they're saying, okay, now I think let's apply. So this is one of the most crucial mistake that people do. You should not be doing it. Your entire business is your idea. The second after 6 months your idea is launched, idea is making revenue, there will be many sharks around who is ready to copy that and create a different kind of a business. You do not want that. You want to make sure your business is unique. Your business stays yours. Your idea remains yours. And how to make sure that idea remains yours is by applying this at the right point of time. So don't wait for launching your business. Don't wait for getting revenue. If you have a unique idea and if you have a confidence of this on the same, apply for it right away. Third aspect is your work is not done once you have applied. Your work is not done once you have applied. First thing you have to make sure is you have to see through it. You have to make sure that your trademark, copyright, patent, design, it goes through the end. Many of the times people feel like, okay, let's drop it. Don't drop it. You created a brand, you created a unique idea. Take it through. Second major aspect is to make sure to check that there is no infringement or violation of your IP is happening. That is the important aspect. As I said, you need to make sure that the idea remains yours. And it's a very common practice. There are people who will be finding any unique ideas that any one of you attending this webinar would be having. So make sure once you have created a business, once you have created an IP, get a proper watch for your brand, for your IPs, get a proper IP infringement checks done at regular intervals so that you can take appropriate actions against anybody who is copying. The reason only if you do not take what is the again my point everybody's mind would be okay why if I don't I'm running my business. I'm running my business. Why should I do take efforts, spend time, spend money on it? The reason you do it is you run a business to make money. To make money. The fact is if there are 10 people doing the same business, you have right away shut down your business by 1/10. So nobody wants that. Everybody. So that's why you want to make sure that your market stays intact, specific to you. Your market reputation does not get ruined because somebody is selling a what else, counterfeit material or a low quality material, which not only they are not only have taking away your business, they are hampering your market reputation also. So these are the few things whenever you're launching, make sure to do it. And yes, as I said in the very start, do a search. Whenever applying for IP, do a search before.
So, Karan, like to summarize what you said right now with this question for the IP protection, the first part is the timely filing. That's number one thing I hear. And then do a proper search before applying. That's the number two. And number three, I guess it's keep check of the infringers, trying to copy. Fourth is IP clauses, finding out, clearing it that, check with the IP clauses. And then at last, run for a due diligence. That's what you're trying to say. When you keep these things intact, these clauses keep on checked, then I think your brand positioning or visibility there in the market will be even more stronger and you can establish a brand, right? Thanks, Karan. This is a very meaningful time of interaction. Now we'll quickly go to the audience for their questions and their feedback. Okay, well, one of the contestants by the name Mr. Amit is asking how to check the like design that is whether it is chosen or not. which is not owned by him? Like how to trace the patent search or design search?
Okay. See, with respect to that, there is a basic search mechanism that all IP lawyers have and follow. They have databases access from which they can check if there is a similar design already applied for the same or not. So again, you can connect with any of the IP lawyers, ask them to do a design search. They will give a detailed design report stating all the different kind of similar designs already in the existing market, and with the basic percentage or the chances of success. Ki, okay, your design is unique or no,
Yeah.
your design is a bit similar, and you have to differentiate it accordingly. That will be the
Okay.
great report that we require for.
Yeah. Thanks, Karan. And I think Mr. Ashok is asking a question, but I think his question is not closely relevant to this webinar. He's asking about the difference between the trust in the society. I think we have covered a little bit on this in the previous webinar as well. Or if you wanted to talk more in detail, our experts are just one call away. You can check out the number in the description, or visit our website www.vakilsearch.com, and you can talk to us, give us your details, and our experts will be calling you back, and they'll give you a elaborated understanding on the differences, and help you register on what you wanting to register. Karan, there's one more question that just popped up. That is, one of our viewers want to know, what is trademark watch?
Okay. See, trademark watch is simply watching your trademark. Again, I will differentiate between trademark watch and infringement check. So, trademark watch is wherein we keep a watch over any kind of similar trademark that is applied at the trademark registry. Every week, thousands and thousands of applications are applied by individuals across India. So, you need to keep a check if somebody has applied for a similar trademark of you. So, for example, again, your mark is Amit Awesome, for example, and somebody has copied Amita Awesome, and they are selling same apparels just like you. So, this is a case wherein somebody has copied your trademark or made minor changes to it. So you
Exactly.
need to take a legal, you need to take action against them by filing a kind of a trademark opposition proceedings at the trademark department and take appropriate action against them. This is one of the important aspects because sometimes the trademark registry they have a very good system of their due diligence wherein they try to raise any kind of similar trademarks at the objection stage itself. However, still sometimes some marks pass through. In that case, trademark watch is an important aspect wherein you need to check if there is a similar trademark that has been applied by any third party in the country. On the other hand, infringement check is wherein you can check if anyone has applied or anybody has not applied, has used the exact trademark or a similar trademark on any portal across Google, across web. So be it Facebook, be it any social media platforms, be it e-commerce platforms. So there are many times infringers, they do not even apply for the trademark or the copyright. They simply start their brand because they have copied your brand. They want to make a revenue of few months and they will move on to the next major brand. So they simply do not apply. So you need to have a very strong check on these infringers. So this infringer check or a continuous watch on different platforms in a strategic manner is something that you should have.
Okay. Thanks, Karan. Karan, one more question. I don't know whether we can put numbers over here, because one of our viewer wants to know the penalty for infringement of any, if any case arises. So, can we say the numbers here, or?
Okay. See, with respect to infringements, again, with copyright has a very strong copyright among all has a very strong law wherein there are both civil and criminal action can be taken against you. So you can directly file an FIR against somebody who has infringed your copyright in the work, and that person cannot just not only be what do you say, just not only be penalized in the court, but can even be arrested for copyright infringement. Similarly, for trademark also, it has both civil and criminal remedies. However, criminal remedies is a bit tough or it's a bit lengthy process to get the relief as under criminal law. But yes, even in the civil law, Not only you can just stop a person, but you can even conduct raids at the houses and the warehouses of these people. You can file a
Okay.
case under the district court and take action against them, file on trademark infringement and get an injunction against them, and get their house or the warehouses where they are making counterfeit or infringing products raided entirely. So there have been
Okay.
various changes, like in various in various cities, Patiala, Delhi, where there are warehouses of thousands and lakhs of products. There are various raids currently going on across India to stop the counterfeiting or trademark infringement happening. You can do those.
Thanks, Karan. The next question is one of the viewer by the name Namita. She's asking, how can I ensure my IP application is strong and defensible against potential infringements or challenges in the near future?
See, again, whenever you're applying for IP, whenever you're applying for any IP, the first and foremost thing is be make sure to do a proper search term. Once your searches are very clear, once your searches are very detailed, you are at least shutting out 60 to 70% of any kind of infringements or any kind of brand risks or the IP risks that might happen to you. The remaining 30% that is left is by doing a proper watch and check of any kind of infringers. So by doing that and
Okay.
taking appropriate and timely action against infringers, you'll be ensuring that your IPs remain strong. IP strength is again, it's not only important on the aspect of just for the sake of it that nobody comes or infringes your trademark and creates an identical business, but even it is a very valuable aspect in the valuation of your company. Whenever you are valuing your company, whenever you are trying to get funds and investments, it's a very important aspect which is checked as a part of your due diligence check before an investment is made, that how strong your IP is.
Yeah. Okay. Thanks, Karan. Thanks, Karan. Now, Karan, this is something that I wanted to ask. One of the viewers also asked this question. How do you think that as an individual that I can stay updated with the latest changes that are happening in the IP laws and regulations? What are some steps that I can take and adapt and optimize my IP protection strategies?
So firstly, yes, again, we have, you can, Vakilsearch has a website from where you can keep on getting regular updates, has different blogs from where you can keep on checking
ठीक
the
है.
recent developments that is happening across. Secondly, even whenever you are applying through your autonomies, you can keep on checking if there is any recent updates or major development that has happened in the IP field. Third aspect, what you can do is you can be abreast. There is IP India website, ipindia.gov.in. All the latest developments, all the latest news that is happening is there on the very front page of the government website itself. From there also you can keep yourself updated.
Okay. Thanks, Karan. Well, we just got one LinkedIn user asking a question. What are the potential implications of IP licensing, assignment, or transfer agreements? How can I ensure my interests are protected in such agreements?
Okay. Okay. So again, IP license, IP assignment, or transfer agreement. These are, if we can bifurcate, there are two basic kind of agreements in IP. One is a license agreement, other is a basic assignment or a transfer agreement. License agreement
ठीक
is
है.
when you have created a brand and you are licensing 10 different vendors to use your brand. And assignment is wherein simply you are giving entire rights of your brand or your IP, or be it IP can be patent, copyright, patent design, anything. You're giving and transferring the entire IP to somebody else at a major lump sum consideration. And IP license agreement is going to IP license. Firstly, whenever you're getting an IP license, you have to make sure the intellectual clause is very specific. So make sure that well, the clauses have a very clear bifurcation as to the period. So for how long the period is. Many times you license it to somebody and they keep on using the specific brand name even after the license has expired. That's a kind of breach of contract. So make sure
Okay.
to take over that. Whenever you are granting somebody to use, make sure to keep specific clauses that they cannot create different versions of the same brand name at a later point of time, or they can use that for their own promotion or something. You, as a brand, when you are giving somebody's licenses, You want to make sure that the brand retains with you. Even if you're giving the somebody license to do a business, make sure to have a very strict clauses of what are going to be the repercussions or what are going to be the next stages once the license expires, or what are the limits the person to whom the license has been provided has to remain within. It has to remain some boundaries. You have to follow some company policies of the licensor who's giving the licenses. Okay, you can use this brand for selling of this products. You cannot venture into this. All those
Okay.
aspects made very clear and in detail. IP assignment is something wherein you transfer the entire IP altogether. You get onto a specific purpose, you are assigning the specific IP for this much, for this crores or lakhs amount, and you mention both the parties, and you create an agreement around it. To make the agreement actually enforceable,
Okay.
what you have to do is you have to actually file in applications or some amendment applications with the trademark registry or the market office with this line of get the ownership of this application changed. It was with Karan, now it's with Charles. That is what you have to do. Once you put it on their record, it will be taken from there. It will be taken from there.
Okay. Thanks, Karan. Karan, we just got one other question. That question is from Mr. Punit. It says that his trademark keeps on getting objected. He's asking what can we help? Like, how can we help them?
Okay, so again, while your trademark, once you apply the trademark and it gets objected, once the reason again, as I said initially, your trademark might get objected on the basis of it being similar to a trademark already existing in the records, or the mark might not be very unique or descriptive. So in this
Okay.
case, again, if you have still have a time to file a response quick. In that, get a lawyer who can explain a very detailed and small differences that is existing with your trademark and the similar trademark. Get that aspect done. If in case your mark has got objected and it has got refused after that, and you have to reapply the trademark, get a detailed analysis done. Ki what was the reason that it got objected earlier? And when you are applying the trademark again, make sure to all the aspects on which it was refused to make sure that when you reapply it, those similar objections does not come. So, like if it was
Okay.
generic, add a very unique or a non-dictionary word before that. If they said it is similar to another existing trademark. So make sure add additional textual aspects to it, add additional artistic aspects to it to make it different from the existing trademarks. If it is descriptive, if any descriptive aspect is very evidently mentioned in your trademark, either remove it or make the presentation of it very small in your trademark. So once you reapply with all these changes, the chances of acceptance will automatically get high. And in case your mark is under objection stage as of now, get a detailed reply, get a response file, get into a touch with an IP lawyer. Don't try to respond it at your own end because there are various technical aspects that you need to mention. Whenever you file a response, make sure that there are some judgments and legal arguments and legal principles mentioned therein. So once they have all those pointers added, let's file the response.
Thanks, Karan. This is such an important question because most of us have the same question because the trademark keeps getting rejected. And for all the viewers who are watching out there, we just wanted to say we would be delighted. Our experts would be delighted to get on a call with you, discuss over your product or like whatever you're trying to get your trademark for, and understand and wanted to get things done at a very simple and in a very fast manner. So for people, those who wanted to get things done, we have a form that is given below and you can register and our experts will get in touch with you. Karan, we have one last question that just we have. This is a question that is from Mr. Sumit. He said, kindly guide a strategy to deal with Section 9(1)(b) objection. Mark consisting of words serve in trade to designate intended purpose.
Yes, yes. So again, this is one of the I would say, as I said, three major kind of objections comes, and this is one of the objection as to the mark that is very descriptive. And the example is, you cannot apply for the trademark Apple for selling apples, apple fruit. So again, when you respond to this, you have to touch base upon two to three major aspects. Firstly, you have to explain how your mark is artistic. If you have any artistic features, if you have applied for a logo trademark, press upon the artistic aspects in detail. Second, you have to focus and bring forth to the registry's examiner's knowledge. Sir, this is the descriptive aspect. For example, you applied for Sumit Singh phones, so you have to explain this Sumit Singh, and the logo is elaborated. The focus point of the entire trademark and phone is just very small and minuscule part of it. It's not even, you can file in, you can showcase some documents to showcase the way of
Exactly.
representation of my trademark and putting up the unique aspect in much more focus. And this aspect of the phones is very minuscule and not evidently visible. Aspect, what you can do is, you can file a small amendment by filing a form TMM disclaiming any rights over the generic or the descriptive term. So it's a
Okay.
kind of amendment where you're saying कि we do not claim an exclusive right over the descriptive term. We claim right over the entire mark as a whole. And final point, and the most strongest argument is, that is the proviso of Section 9. That proviso specifically says is, if if you have a user, if you have a user of a trademark, prior user of the trademark at the time of applying of the trademark application, you will be able to overcome this objection. So if at the time of application, if you feel that your trademark might not be very unique or might have some other descriptive contents, make sure you apply the trademark claiming user. After months or years, to claim user, it gives an impetus to the IP registry to
Okay.
showcase that I have created a reputation by using the trademark for these many months or these many years, and over the time I've created a reputation in the market, and it has become common in use, and I have acquired distinctiveness by using this trademark. So by using these three to four aspects, you can very well overcome the objection of 913.
Thanks, Karan. Hope I believe that Mr. Sumit's doubt has been clarified. Thanks, Karan. This is such a meaningful discussion that we had over the period of the last 45 minutes on the best practices for IP protection and enforcement. We just wanted to inform this is a series of webinar, and we look forward to communicate the upcoming dates for the next webinar as well. But the giveaways and the freebies that we would love to say is that for all the attendees who have registered and also viewing, is that we would be glad to create a free infringement report for all the attendees and share if anyone copied, whether their brand name or plus IP expert consultation is being part of this webinar registration. And also, we would be glad to give away this TM Watch service at a discounted fee, which, because we cannot provide the service for free because there is a contract fee of INR 500 involved. So just making it 300. So the overall cost for this would be 799. And if you wanted to avail this service, yeah, there is a form that would be there in the video description, or also we would be sending out the emails of the forms along with it. Take a time to fill in the form, give us your feedback. What are some of the things that you wanted to discuss about in the next webinar? And if you want to talk to our IP expert, just fill in your details. We would be excited to talk to you and take things forward for your brand and make it register. Thank you so much, Karan, for joining, and we look forward to see you in the next webinar. And until then, we signing off. It's Charles, and thank you for joining.